Hi, Amy and Asha.
Good afternoon. Hi, Laura. Hi,
Hi,
Asha.
how are you? Hi,
Hi,
Doing
Asha.
great.
Laura.
I had to kick my
Amy.
kids out of my office.
I know I told mine to, stay, no making loud noises, no shouting outside vibes. So
We'll see if it works.
pandemic, right?
Yeah.
It won't work, you know that.
Yeah, exactly. We know that. They don't know that. We know that.
Well, we are here today. We've got about 240 people logged in right now, and I'm sure some more will be filing in shortly. But we'll go ahead and get started. And so first, welcome to everybody who's signed on to see this webinar, which I'm very excited about. This is going to cover how to negotiate compliance contract provisions. And this is an area that I've been wanting more guidance on for a long time. There's a lot of general compliance guidelines, but very few that kind of talk to these provisions and what transactional lawyers need to know and what compliance folks need to tell them. So I'm very excited, and especially because of the speakers we've got. We did a couple of calls in advance, and I've already learned from them from those calls. So I'm very excited for their expertise. Now, before we get started, a few housekeeping issues. The first is there will be a web recording and a copy of the handout sent around tomorrow by Law Insider. So you can look for that then. If you have questions, we ask you put them in the Q&A tab at the bottom. You're welcome to use the chat to have conversations with each other during the recording, but we'll be looking to the Q&A tab to determine which questions get asked of the panelists. We won't be looking at the chat for questions. So please move any questions into the Q&A tab. And with that, the general plan is we're gonna do a quick introduction. Amy and Asha will give us an overview of some of the key concepts, and then we're gonna launch right into specific provisions and what we need to know about those provisions. So with that, why don't I start with you, Asha, if you want to introduce yourself, and we'll go from there.
Yes, of course. And Laura, thank you for the invitation today. We know every lawyer's favorite topic is compliance. And so Amy and I are glad to be here. I am Asha Palmer, and I am Chief Ethics and Compliance Officer at Conversant. Conversant is a technology provider for ethics and compliance professionals. And so you can just see how much I love ethics and compliance, because not only is it my profession, but I work for a company that makes it approachable for companies as well. I am a lawyer by background. I am not a transactional lawyer, but I am a litigator. Spent some time at Department of Justice as well as a big law firm in Atlanta. But have been in the ethics and compliance space for about 7 years now. So looking forward to this discussion and being here.
Wonderful. Amy, if you want to tell us about yourself.
Thank you. I'm based in Toronto, Ontario. I've been an Ontario lawyer for about 21 years, and I spent most of my career in-house, either doing in-house counsel work or senior level ethics and compliance work, or even commercial work. And I started my own law practice, a boutique law practice, about 18 months ago. And I basically do commercial negotiations, or I do ethics and compliance programs, either auditing what companies have or helping them to create their improvements to their programs.
Mm-hmm.
And prior to starting this, I actually spent 6 or 7 years working very closely with my colleagues at SNC-Lavalin in building their ethics and compliance program and rolling it out around the world. And I think what Asha and I share is that we understand the relationship and the intricacies between creating your compliance program and actually rolling it out. So our favorite word is operationalizing ethics and compliance. And
that
one component, it is totally our favorite word. Stumble over it all the time.
My favorite word.
And the ethics and compliance terms and conditions is one piece of operationalizing ethics and compliance, because it's nice to have a policy that says you do all these nice things, but how does it affect HR? How does it affect the legal department? How does it affect supply chain? And so today we'll talk about one of those impacts, and that is what you should have or what you might expect to see in contracts with respect to ethics and compliance. And our focus is very much from an anti-bribery lens, but you can apply a lot of these principles to a more broader approach to ethics and compliance.
Wonderful. Well, with that, I'll let you two get started with the presentation.
Thank you. So Ashley's got control.
Yep, I have the agenda up, so.
Okay, so this is what we're going to stick to, and we're just going to jump right into the context so we can time for questions. And at a high level, can we go to the next slide? So at a high level, with respect to context, what I want to build on what I said in the intro, and that is with respect to your ethics and compliance program, there are many components to an ethics and compliance program. One of those components is having an excellent set of contractual provisions. What you see on the screen right now is just one example of where international standards or guiding principles or requirements, however you choose to look at them, where you can find them. This is my favorite one to use because it's a nice 4-page little handout, very easy to read, written in plain language. And these are the integrity compliance guidelines from the World Bank Group with respect to the main components of an ethics and compliance program. And if you turn to the next page, you'll see that in section 6, it will, in particular 6.2, tells you that these are their contractual obligations. So I'm just going to move my monitor here, the little faces. And so what we blew up here in this rectangle is with respect to your ethics and compliance program, one element are contractual obligations. And so the instruction here is your employment and business partner contracts should include express contractual obligations and remedies and penalties in respect of misconduct. And this can include misconduct from business partners, from contractors, from joint venture partners, whomever you have contracted with. So the purpose of these last 2 or 3 slides was just to give you some sort of a broader context of why we're even talking about this, right? Like, why are you seeing these provisions in your contracts, or why should you have these kinds of provisions in your contracts? And you can find this World Bank guideline right on the World Bank's website.
Yeah, and that sort of brings us into, what you need to think about when you see these contract provisions. And, we are very used to having what we all call boilerplate agreements. And then we modify sort of those boilerplate agreements to the deal or to the relationship. And there's no different approach you should take toward the compliance clause. It should not be boilerplate. It will not be the same in every contract that you experience, but it really will vary based on your position and the context of the contract. So these are just some of the considerations. Are you the buyer or are you the seller? Is it a partner, agent, or is it a vendor agreement? Is there government interaction? What countries or country is the contract being performed? Will there be sub-delegation of certain parts of the contract? So say you will hire a third party or otherwise. Is it a goods contract or is it a services contract? What's the total value? What's the relationship between the parties? So it's those type of things that will change. And we want you to keep all of those in the back of your mind, because that will change how some of these compliance contractual provisions should be phrased or should be approached. And we will really get into where you can negotiate and where you can't negotiate depending on these considerations.
And what I'd like to add, oh, sorry.
Yep. Yeah.
So what I wanted to add to what Asha has already said is that really this list of questions, and these are just some of the considerations, this is all part and parcel of what's considered a risk-based approach to ethics and compliance. So for example, if I've got a contract where my company is providing engineering services from my home office in Toronto to a buyer who might be in a country that has a very low corruption perception index score, meaning that it's a likelihood of more corruption there than in my jurisdiction. My concerns about ethics and compliance and the clauses are not as high as if I was doing construction work or if I was procuring goods and equipment and shipping it there. So you can also take a risk-based approach to what is my scope of work? And if my scope of work entails a lower degree of corruption risk, then perhaps that also gives me some comfort that, depending on which side of the table I'm on, maybe I'm going to demand greater ethics and compliance provisions, or maybe I'm going to be comfortable saying, you know what, the overall risk here is low. So I can take that into consideration as I'm drafting or reviewing someone else's terms and conditions.
Amy, can I ask, you mentioned a corruption perception index. What is that?
Well, funny you should ask, because today, January 28th, 2021, the 2020 score list, this list came out today. It comes out once a year, and it's published by Transparency International, their main outfit out of Germany. And it is a perception index score. And so what they basically do is they rank almost every country in the world, if not every country in the world. The lower your score, the greater is the perceived risk of corruption in that country. The higher your score, the less perception of risk. And so what many companies do is they will tie, like, let's say if you have an internal risk assessment process, you might say, okay, in our company, we are going to flag any deal with a country with a score below 40 as requiring heightened ethics and compliance controls, possibly greater anti-corruption language or greater monitoring than a project or a client who might be based in a country with a corruption perception index score is higher. So usually we call it CPI, and you are seeing a lot of companies who will use that as a benchmark to help them assess corruption risk. There's other tools out there. It's not the only one, but it kind of is well known. And, if you look on your LinkedIn or your social media, all your friends are going to be posting about it today. Or some of your friends.
And if I can add to that, Amy, to break it down even more, right? The things that you need to get from this is, one, know that there is something called a corruption perception index, and that it's tied to countries, right? And it's tied to countries based on a number of factors. And so really you need to just check what countries are implicated in the contract, where are you located, also where will that contract be performed, and by whom, right? And so all of those things are going to matter as to what you want to negotiate and what you don't. And we're going to go through this on a very practical basis, and we'll talk through some of the things that may change depending on their CPI score. And so you will see that in place as we talk through these next provisions. With that, I will jump into our first provision, which is an anti-bribery prohibition sample clause. And what Amy and I have done to sort of highlight the important parts, or the parts that could be negotiated in any given term, are the ones that you see in red. And the first one to talk about, this is a standard clause that you may see in a contract, either that you receive or that you've drafted. And essentially what the clause does is outline what are the requirements under an anti-bribery law, right? So there are a lot of international anti-corruption laws, some of which are listed in this clause. So the US Foreign Corrupt Practices Act, the UK Bribery Act, the Canada Corruption of Public Officials Act. There are many anti-corruption acts. and laws. And so you would need to know which ones are applicable to that contract, right? I always say you don't want to voluntarily opt in to anti-corruption laws that don't apply to your business or the business under the contract. So it's really important to look at what are the standards and what anti-corruption laws are listed in any anti-bribery prohibition. Laura, you have a question?
Yeah, can we just be vague about it and say any applicable bribery laws and to the product or the contract?
Yes, so I tend to favor the any applicable laws standpoint because it makes sure that you are, again, only being held to be compliant with laws that are applicable to your business. So yes, that is an approach. But you can also think about if there are all of these laws have different requirements. And so it is very important that you understand what the applicable laws are and that the clauses actually address those. Amy, did you want to add something there?
Yeah, I'm like chomping at the bit here because I have a slightly different perspective. And if you're coming at this from the point of view of a very conservative lawyer, you're going to have one perspective. If you're coming at this from the point of view of you're a bit of a, standard bearer for ethics and compliance, I would say you're going to come at this from a different angle. So what I wanted to add to what Asha said is, yes, the laws have differences, but by and large, I would say they're nuances, right? Like looking at the ones on the screen right now, the biggest difference that jump out at me is that the UK Bribery Act it prohibits commercial bribery, whereas most, if not all, of the other international anti-corruption laws focus on public bribery, meaning bribery of government officials. So if you don't want to give the message to your community, whether it's your internal stakeholders or external stakeholders, that, hey, we're not going to follow the UK Bribery Act and therefore it's okay if we have commercial bribery. Like, obviously, that's not the message anyone is trying to send. And I think that sometimes it is easier to get yourselves internally and get the other party to kind of meet, let's say, the highest standards. Secondly, if you take a look at who is it that is enforcing. Right now, we're seeing a lot of enforcement, and we have historically in the US, we're seeing a lot more enforcement coming out of the UK in the last few years. You're seeing enforcement in places like Brazil. Like, it's not, you also have to look at where the active areas of enforcement are. And then finally, some of these laws and some of the ways these laws are enforced can be quite broad in terms of you might not realize that there's a nexus between that law and the work that you are doing. So if you think I'm in country A, my supplier's in country B, we're shipping the goods to country C, and none of those involve, let's say, the US, well, have you thought about where the money is going through the exchange banks? Because we have seen cases like that where that might be enough of a nexus for the US to claim jurisdiction. So I'm not here to talk about all of those nuances, and I'm sure there's lots of people on the phone with more knowledge than me who will tell me I'm right or I'm wrong. But for anyone on the phone who is new to the area, they should understand that sometimes you might not expect a jurisdiction to be able to have any kind of connection or nexus with your project. But we are seeing, and we have seen lots of cases where that nexus seems to really surprise people. And it could be something as sort of out of mind as which, wire service the money is going through. So yes, I agree with Asha. Make sure you understand which laws could apply, but don't be overly narrow.
Right. And also, though, don't opt in to laws that you may have a later argument don't apply. So, in that situation, you just gave country A to B and C. If none of those were the US, then I would not include the US Foreign Corrupt Practices Act in my contract. Because as a litigator on the flip side, or Department of Justice, I would say, hey, you said it applies. but you didn't adhere to it. So I think both of our points are very important, but you have to make sure that you understand what the nuances of those are, and so what you're committing to. As Amy said, the public corruption or the public bribery part is really what's in the next red sections, right? Prohibit any direct or indirect payment of money or anything of value to a government official. As Amy said, all of those laws listed above and most anti-corruption laws have this element of public bribery in them. Amy's really good point about some of these also prohibit private or commercial bribery, and that's important to know whether the laws that you are committing to have those requirements. And then I just want to skip down to the last part, and Amy and I will talk about sort of two different approaches too. You know, if this is in a contract and you say, I agree, I'm going to comply with these laws, I'm not going to bribe any public official or make sure that my employees don't either to retain or secure an improper benefit, great. But what good does the acknowledgement do? And that was kind of the point that Amy was making earlier. Is this a multinational company, or is this an individual contractor? Is it a contract for goods or for services? Depending on those nuances will depend on what guarantees you want from that party on the other side of the contract to show their acknowledgement and therefore their controls around bribery. You don't just want someone to say, yeah, okay, I know there's anti-corruption laws, that's great, I won't do it. You want to ask them for more prescriptive assurances as to how they are actually controlling for that within their organization. And Amy, I know you wanted to add to that.
Right. So I think, you know, if this was, let's say, a sophisticated party where you had some independent knowledge of their level of, you know, the kind of ethics and compliance program they had, you might be satisfied with the contract saying each party or that party acknowledges the anti-corruption laws and, like, you know, they won't violate them. And you might say, well, why do we even need that? Because we probably already have a compliance with law section. Right? To Ash's point, what if they're not a very sophisticated company? What if they're a small company? What if it's their first time doing the kind of work you're asking them to do? Like, what if you just don't have that degree of comfort that they're going to actually understand what they're signing up for? And so in those cases, you might want to be more prescriptive and say, you know, here are some of the main things we want you to be aware of, such as making sure that you understand you can't bribe government officials, as in the paragraph, the first paragraph. And you might also have other expectations, such as, and Asha will get to this later, but you might want to see if they have a registry of who they're giving gifts to. You might want to see some examples of how it is they conduct themselves with government officials. The point about what kind of internal controls they have, I mean, you would have the ability to ask yourself, what do you need to see with respect to your company or with respect to the industry that you are in? What kind of internal controls do you want to see that would give you that comfort that this company that I'm dealing with understands the risk and they're taking appropriate action to limit themselves or limit their behavior?
Is that the only reason? Is because, again, we're always, and we had this conversation too about, you know, there's the compliance folks who wear that hat of, you know, all day long, every day I do compliance and make sure my vendors are in compliance and suppliers are in compliance. But for those of us who are segmented in a more transactional role, you know, when, excuse me, we don't, I mean, not that I don't care if the other side's in compliance, but that's not my immediate problem. My immediate problem is getting this deal done. And if the other side's pushing back on this provision, what is it? Do I say my company requires this and leave it at that? I've heard of
I would say, so going back to the earlier slide of considerations, right? If this was my supplier, I would have less concern. But if they could be in any way interpreted under the anti-corruption laws of whatever jurisdiction to be doing something on my behalf, well, then I can be liable for what they are doing.
Right.
So if it's my joint venture partner or an agent or a representative or, sales agents, for example, are extremely high risk, I would want to be as prescriptive as possible because I could be held liable.
That
And
makes
so
sense.
sometimes what you're seeing here, and obviously this is going to slow things down, you might want to, this might be the opportunity to find out what they actually know about the area and save yourself a whole bunch of litigation hassles down the road.
Yeah. And then
And
the
Laura,
other reason was, your executives can go to jail for, this isn't like you just
Ah,
lose
yeah,
money.
exactly,
Your
exactly,
executives go to
exactly.
jail if you mess this up, kind of thing.
yeah.
Yeah,
And if I can just add to that, right? I think Amy's point about you will learn a lot about their compliance program, right, is very important, right? If they're pushing back and they can't show you any controls they have in place to mitigate for this, that to me is a red flag, right? So usually when there's a company who's fighting against any controls, they do it because they have different controls in place. And our conversation is just about, it's not that I won't do that, but this is how we approach it. And so a red flag would be if no one has any type of controls in place, as opposed to if the controls are just different than you've outlined in the contract.
Got it. Okay. We'll keep moving because we're almost at 12:30 and I know you have a lot to cover.
Yeah, so Amy's going to cover the audit clause.
okay, I know it's everyone's favorite topic, but basically the audit clause and the clause that's going to come next, termination. In many agreements, you will see the anti-bribery clause containing all three elements in one subsection. So there's the prohibition on bribery. And then secondly, this audit clause basically says, well, I want to make sure that I'm comfortable that you're not committing any bribery, whether it's intentional or unintentional, or whether head office knows about it or doesn't know about it. And then the next slide is termination, right? What rights do we have in the contract to terminate if the results of the audit are unsatisfactory to us? And so if we can just go back to the audit, I just want to point out a couple of the things here. And again, we understand that the people who are participating today might not be the experts in ethics and compliance. And let's face it, maybe your company doesn't have anybody who's an expert in it. And so that's why we want to highlight some of these things to you. So one thing that you could look for in an audit clause is you want to be able to audit any kinds of expense reimbursements, right? I won't get into the weeds of that, right? So there's expense claims, but expense claims won't tell you the whole story. Because what if I've received something, right? There might not be a paper trail for like an easy paper trail, like an expense claim. So you want to see expense claims. You want to know about any payments that they have made to third parties. You also want to know if there have been any benefits that have been conferred to third parties. So for example, is this company buying Formula One tickets and then giving those tickets out to government officials? Because this could be a huge problem. These tickets could be worth a lot of money. They could be violating the government rules in terms of receiving gifts, and they could just be causing, they basically would constitute a bribe under many of the tests set out under the various legislations. And then the final point we wanted to mention was I might want to retain the right to come in and do the audit myself, or I might want to hire a third party that's going to come in and do the audit. And the last point to consider here is if you're in a joint venture or a consortium, or you've got a major supplier, or you're the major supplier, sorry, I should limit this to joint venture and consortiums, you might make this a reciprocal clause. And so for everything we're talking about today, if we're talking about contracts that are very reciprocal, you have to be able to accept these terms and conditions to apply to your company as well.
Yes, no, and I agree. And I think, as with every contract, right? The other thing about an audit clause is don't have it in there if you don't intend to actually audit the company. And so you really have to think about if this is in a contract given to you, or you, particularly when you're the one submitting the contract to another party, don't put in an audit clause that you're not going to actually ever do an audit of. A lot of times we see those in there as intimidating factors, but on the flip side, if you do come into contact with a problem or a government agency and you never exercised your audit clause, that sometimes can look worse than even having it in there.
And I would say, and I just saw someone's comment in the comment box. If you talk to people with respect to their ethics and compliance programs, I would say that actually performing the audit doesn't always rank as high as it should in terms of activities to do. There's a lot of, let's get the agreement in place, and then we're not going to worry about what the agreement says anymore, because I got my next agreement to work on. So, but Asha, do you really think you shouldn't put it in? Or should you instead make best efforts to actually do the audit, maybe talk to the internal audit department and see if you can come up with an audit plan of some kind?
Yeah, I think obvious best practice is definitely to audit, right? If you have the capacity to do it. And so, this could go actually on our pass the torch slide at the end, as if there is an audit clause, to connect with internal audit on that plan for sure.
Okay.
Okay.
Okay,
Let's go to the termination clause. Oftentimes we see termination clauses in contracts in general. They're usually all the way at the end and can be vague, or say, any material breach of the above clauses is rights for termination. A lot of times that lends us to an argument as to whether violation of an anti-corruption law or any of these other clauses we'll go through after this actually are material enough to substantiate a failure to perform. And so our suggestion, and Amy and I have talked about this lots of times, is if that is the position of your company, which we believe that it should be, that failure to abide by any of these compliance contractual clauses that we have today would be a material breach, to make it explicit in the contract. So to move up this type of termination clause so that it directly follows any other compliance provisions that you believe would be a material breach to that contract. And that way it makes it very clear to the other side that we are agreeing that any violation of these compliance clauses would lead to termination, and we would be able to end the contract.
And I'd say just knowing some clients I've worked with and companies I've worked for, be very careful of that if it's mutual, because you may expect your company would never do anything wrong, but often things happen and we violate laws without necessarily intending to.
And Laura, I'm sorry, I was going to say, I'm glad, Laura, you raised that, because obviously the perspective Asha and I are coming from is that companies should have strong ethics and compliance programs. That's the work she and I have been doing for a long time. And what I would say, Laura, is if I was sitting across a negotiating table from a company and that was a position that they took, it might be legally justifiable, but I would certainly be picking up my phone, calling the compliance lead or calling the business lead and saying, this is a red flag. This company is not as committed to ethics and compliance as we are. They're pushing back on terms and conditions that we think are quite basic. Are we sure that we've appropriately done due diligence on this company? Do they adhere to the same values of integrity or ethics that we have? So yes, you're absolutely right. There could be good, rational, and drafting and legal reasons to push back. But if you're dealing with a company that really is quite committed to ethics and compliance in a very, as I said, operationalized way, or even just at a values level, that's going to be a bit of a red flag because they're going to be like, well, why can't you agree to something like this? So
And
that,
what I was going to
yeah.
say is one of the things that transactional lawyers love is playbooks and, clear lines. If this, then do that. So made famous by Lisa Lang, one of the great contract people on LinkedIn. So I would say, I mean, what I'm hearing and what I'm thinking as I'm processing is maybe create some of those standards. Like if they won't agree to this, just like if somebody rejects our insurance provision, we send it to the insurance or provision, we send it to the insurance lead. If somebody won't do this, these kinds of things go to the compliance lead and they have to approve before you can move forward. Something to that effect might be a good system, but of course, first you have to figure out what that is and what your tolerance is. And that goes back to the theme of knowing what your company's position is.
Right.
Right.
Okay.
And I think, it's so important to figure out where your red flags are. And someone asked a question in the chat about, what if the company we're dealing with has their own ethics and compliance code, right? If they have a mature program or have invested in their program, those are good signs, right? And none of this should be shocking or appalling to them because they are living by those standards within their organization as well. I think we find a lot of pushback and challenges with companies that are smaller, that are startup, that are single individuals, contracts for services particularly, as opposed to goods. You'll see some more negotiation. And I think that's where the risk is higher. And so you have to determine your company's risk tolerance for sure, and what they're willing to take and not take.
And one quick thing before we move on, I wanted to say, I don't think I mentioned at the beginning, on the questions and the questions tab, you can actually vote for the questions you want us to answer, because we're up to 16 questions and we're trying to answer them as we flow. But if you do a like for the questions, they'll rise to the top and we'll make sure to focus on those the most. Okay, sorry.
Yes.
Keep going.
And I'm also trying to answer some of them in the chat when Amy's talking. So I'm multitasking as much as possible. Okay, I think, Amy, are you doing conflict of interest?
Yeah. So with respect to, and I'll keep my comments short because just we want to make sure we get to the questions. And so you will often, but not always, but I see more and more conflict of interest provisions in contracts. I'm seeing it more when it's a government or a government agency or a crown corporation, as we call them in Canada. So I am seeing them more and more. And so I would recommend everyone get familiar with them. And a couple things to be aware of is in this particular clause, you're seeing a few different things. You're seeing, one, we're confirming that there's no conflict of interest at the time we're entering into this contract. And two, if we become aware of a conflict during the life of the project, you can tell I'm a project lawyer, during the life of the services, we will notify you. So there's this positive, there's a confirmation that as of today, there's no conflict, but also moving forward, if we become aware of one, we will let you know, right? In the second paragraph, right at the bottom, what I wanted to flag for you is this wording says if there's an actual or potential conflict of interest. So if this is not an area of your area, when we talk about conflicts of interest, I often talk about three kinds: an actual conflict, potential conflict, but also the perception of a conflict. And so different companies have different threshold levels of what they are comfortable with. And so the perception of a conflict can be very important when you're talking about the speed with which social media or the public opinion can just turn on a dime on a particular issue, right? We've seen lots of examples of where the headlines look bad and maybe the investigation comes later and then there's a determination that, oh, everything was actually fine. It looked funny, but upon further investigation, there was actually no issue there. So I like to put in actual, potential, or perception of a conflict. I just wanted to differentiate that for people where that might not be your bread and butter. And then the other parts we've highlighted is obviously you don't want to take money and get a financial benefit from what it is, some like side deal you're making or making money off the back of something else. But it could be more than that. It doesn't have to just be money. It could be some kind of benefit that accrues to you, to your family. So conflict of interest could actually be quite a wide. We could have a whole separate discussion for an hour or more on conflicts. So just to
really
flag that we really could. So we're seeing more and more of this in agreements, especially when you're looking at terms and conditions that are coming from government sources.
And one quick, and I think we talked about this before, because it's always my concern, not being a specialist, is why would I want to tell my counterparties if I suspect one of my employees did something bad? And the kinds of privacy and other issues that raise. So, when I see that language, I want to take it out, because I don't want to have to tell my counterparty if one of my employees violated a code of ethics or did something else that might be an issue.
Well, again, I totally am sympathetic to making sure that everything's in accordance with privacy. And quite frankly, depending on what the issue is, you might not have to name the employee, right? You might be able to say to your client or counterparty, we've become aware of a situation where one of our people, had this conversation with somebody else, or our construction manager plays hockey with your head of procurement, or whatever. Like, I don't have an exact example right now, but what I'm saying is sometimes in the disclosure or in the process of being transparent, you can make some decisions about how much information you are disclosing.
Mm-hmm.
And you could sort of identify high level what the information is. If the other party then wants to continue the discussion or get more information, you could set out a protocol that says, okay, we'll supply this information to your head of security or your head of compliance or your general counsel. Like, you can try to limit it in that case if you get to that point.
Okay.
Yeah, and if I may just add to that, I think, it goes back to the considerations, right? So, and remember, this is in a conflict as it relates to the performance of the agreement. So I believe a good example is if you hire Asha Palmer to do some work for you, and then I go subcontract with Amy's company because Amy's going to give me, 50% of whatever I send her, am I really picking the best person for my client, or am I picking that client? Am I picking Amy because she's going to give me money back? And so you want to make sure that there's an agreement that says, whatever services you're performing under this contract, you're doing in my best interest and not in your best interest. And that really is what this is certifying. And so we encourage all contracts to have something like this in it, because you just want to make sure that the service providers you have really have your best interest in the performance of those services.
Yeah, and it's a shame you even have to have something like this, but as we said, we're seeing it more and more. I see it more and more from government clients, which whenever I see a new type of a clause come up in a new type of agreement, then my sense is that they are operationalizing their ethics and compliance program and starting to flow down terms and conditions.
Yes,
okay,
correct.
So,
and I'm mindful of time, so I'm going to kind of deal with these next two
sure.
together.
Yep.
And really, this is, a code of ethics. And someone asked, the question in the chat, what if they have their own code of ethics? And that we see either contracts where you tell a supplier or a vendor, you need to supply your code of conduct, or you need to abide by our code of conduct. Mm. Either of those reciprocal conditions are okay, as long as you actually then transfer and see their code and make sure that it has all of the components you would expect of your partner. So there's two ways you can approach a code of ethics clause, either that they abide by yours or that they show you that they have something equivalent to yours already in place. A lot of third parties are reluctant to agree to comply with another party's code when they have their own, because they just make the argument of, I can't keep track. I have lots of vendors. If I had to comply with 400 other vendors' codes and keep track that I'm complying with, it's just impossible. So it is important that you allow people to opt out and say, look, I have a code. We comply with this within our organization. Is that sufficient to fulfill what you are going after here?
Yeah, and I would totally agree with that. And then you're going to talk about supplier code of ethics next, right?
Yeah, and so, you know, another approach as well, and we did this at a company I worked for, is that we created a specific supplier code of ethics, right? And so you've seen within companies, whether your own or otherwise, your code of conduct can be really long, you know, 40, 50 pages. And sometimes a supplier code really breaks those down in a more approachable way and says, here are the things we care about for people we contract with. And these are the things we want to make sure you have in place. And so oftentimes people will have people agree, if not to their own code of ethics or a replacement code of ethics, a supplier code of ethics.
I would say, as a transactional lawyer who's probably short-staffed and doesn't want to spend a lot of time going back and forth reading their code of ethics and that kind of thing, I would encourage you to encourage your organizations to create a supplier code of ethics, because there's not everything in your company's code of ethics is connects with or relates to your relationship with a supplier. And then the only other thing I would add to what Asha said, and I was going to mention at the end as well, there's a third option as well, which you see on some big projects or joint venture scenarios, where the parties come together, they create a project-specific code of ethics. And so you're seeing that more and more. And sometimes that comes along with their whole, like a miniature compliance program for that project. If we have time, we can talk more about that at the end.
Yeah, and the last thing I'll say before we go on to sort of the closing thoughts and hopefully get to some of the questions is, you know, there's a part that's highlighted in the bottom that says, we're prepared to apply business principles which are consistent with this. And that's really the important part, right? You know, we can talk about whether it's their code or my code or whose code or whoever's code, right? The important part is that, you know, the principles that matter to your relationship with that supplier are encompassed in that contract. And so a lot of, you know, whether it's sustainability, whether it's, you know, conflicts, whether it's, you know, things like that that are important, you just want to make sure those principles are memorialized in some form or fashion within the contract.
Yeah, and I'm glad you said sustainability. Like I had on this on one of the first slides, but I didn't speak to it. You're also seeing more and more that like issues like modern slavery are being addressed in contracts in much the same way as anti-bribery. So to people like Asha and I, anti-bribery stuff, that's like the floor. Like every contract should have that. But we're seeing more and more with newer regulatory regimes, and in some cases they're not regulatory, they're just, let's call them best practices, you know, prohibitions on modern slavery and those kinds of clauses coming into your contracts. I fully expect to see that kind of language with respect to sustainability and climate change. Like I'd fully expect to see that in the not too distant future, especially as we're seeing more and more climate change litigation. But you know, because I like, Laura, that you're bringing the opposite perspective. And I think it's really good to sort of have that conversation, because ultimately I think that this is the direction things are going.
Yeah.
And so as much, you know, so I would encourage all the people on the call to think about, okay, what changes do we have to make to this wording to make us comfortable with it now? Right? Maybe it's something like the parties, you know, we undertake that we will have a code of ethics in place within 6 months of contract signing, right? And like my background, I'm used to long-term, like multi-year contracts. If your work involves a lot of short-term, like 6-month turnaround contracts, then you might just want to create a very short supplier code of ethics and just apply that to your contracts and just say it's not negotiable,
Yeah.
right? Like you don't want to be spending hours and hours negotiating when you have such a high volume. But
Right.
the
So-
last few, oh, sorry, go ahead.
Yep, I was going to move you through these last two because there's a few questions I think we should
Okay,
get to.
so these are things we're not going to talk about today, but these are the kinds of things that don't be surprised if once in a while you get these kinds of questions with respect to, oh, well, why does this contract require me to supply an anti-bribery training plan as a schedule? And what if I agree to my code of ethics, they agree to their code of ethics, and something bad happens and there's an investigation required? Does my company investigate, or does the other company investigate, or do we both investigate, right? I already mentioned about having a specific joint venture or consortium code of ethics or ethics programs. That might be the kind of thing you attach to your contract as within 30 days, the party shall create this plan, or you might attach it right to your contract. And then the last point, and we could have a whole separate discussion on this, is many transactional lawyers will get sent the RFPs from the clients. And there'll be questions in the RFP itself about your ethics and compliance program or KPIs you plan on implementing during the life of the project, or whether your company has ever been disbarred or under investigation or any conflicts of interest. These might be things that they expect you to raise at the proposal stage, so well before the contract stage. So that's my 2 cents.
Yeah, I totally agree with that. And I think, using that RFP process to be curious about what your program is very important. We at Conversant have a value curiosity and to learn what are the things that are anchoring your program and what are we willing to share versus not share, I think is very, very important. And so finally, it's important that this is after the contract is signed, when you figured out what to include, which again, Amy and I believe all of those provisions should be included in every contract. But you you have to, understand what the approach of your company is, as well as the relationship and where the pushback is. And then really, once those are decided, so audit or not audit, termination or not termination, which anti-bribery laws or applicable laws that you comply with, to make sure that the teams who are responsible for ensuring that compliance know that that's part of the agreement. And that's really what this pass the torch slide is. It really just says, look, what do we agree to, and to make sure that the folks who are responsible for that function actually do it. And I actually think that brings us to the great last one of the questions, which said, I get huge pushback from contractors regarding the right to audit for compliance purposes. What is the best response to that pushback, and perhaps a middle ground position for both parties?
And I was going to answer, at least where, I'm not the compliance expert, but I know how to find middle ground and get deals done. So, and I'd love to hear your responses of what you think. So at first I start with finding out my company's perspective. I have companies that are very proactive about auditing suppliers or other parties. So once I know that, if they are proactive, then I know I need something. So one of the compromises I've done is not to talk about compliance in the audit provision, but instead talk about compliance with the agreement. So we have the right to audit compliance with the agreement's provisions in a very vague sense. And then in your reps and warranties or somewhere else, you've got a compliance with laws. I'll have an ethics program. So that way, that gives you the right. Now, it might not open the door as soon as you knock. You might have to have a discussion with them because they may say, no, that's not good enough. But at least that gets me comfort that if something really big did happen, I have a good basis to ask. What do you think about that kind of approach?
Yeah, I think that can be a good approach. I also think you can do a pull method and a push method instead of a pull. And so instead of you saying, I'll go get some information about your program, say, okay, you will report to me on a yearly basis, and anything above X threshold pursuant to this contract. So you can have something like a yearly report under the contract where they have an obligation to give you that information,
Yeah.
as opposed to you having to go find it or go through all their records, or, ask them for
Oh, I
something they
love
may not
that.
want to give you.
Yeah, so
That's
I like that idea, Asha. The one that I've seen done a lot is where in the scenario that Laura is describing, and Laura, this might already be sort of inherent in what you were saying, but basically stating we have the right to come and audit if we have reasonable grounds to be, I won't say to be suspicious because that won't look nice in the agreement, but if we have reasonable grounds to make such a request.
yeah.
And I think the best way to do it is always to imagine it's going to be reciprocal.
Yeah.
So what wording would you accept? Right. And so and then I think if they're really, and then I would really talk to internal audit, not to give them more work, but to understand what their audit plan is and to understand if, okay, in the next 1 to 2 years, do they have plans to go and audit any of the joint ventures or the big projects or where I might have large suppliers? And is there a way to build this into what they're doing?
Which I think also leads us to that next question, which is about being a startup and working internationally, and how do you do with it? Because I know I was at one startup that had 150 people and no audit function. We had, finance and accounting, but no audit and no compliance. It was just one lawyer. So again, this is a little older. You don't necessarily see that as much, but there are plenty of companies out there. I mean, I talked to one company that had 80 employees and nobody in supply chain or purchasing. So just everybody buys across the company. So
well, then I would,
it's harder in those cases to have consistent compliance with purchasing policies when there's no one person purchasing.
so is this a scenario when so those companies were the buyers of services? Is that the case? So they were
she
wondering.
said the question is asking, or he's asked, every country has different regulations. What's the risk for a startup in accepting all the requirements, all the compliance requirements? How to find a balance?
I see. So you're saying that it's my company, I'm the startup.
Yeah.
I actually have no processes in place to see what my employees are doing.
Yeah.
And I think you do have problems then.
Well,
I think you have problems if you're not going to invest the time to create structure, and you could see yourself having safety problems, environmental problems, like all of these problems fall from that same lack of structure and lack of governance.
Yeah, and Amy, I read the question a little differently. And I think it was when we were talking about sort of the international regulations or anti-corruption regulations. And I think they were saying, like, should we just list all of the countries that we're doing business with, right? So should we, the US Foreign Corrupt Practices Act, the Canadian law, the Brazilian law, all of the laws. I think that is more of the, should we agree to, submit to all of those requirements? And so I would go with either the applicable route, say all applicable laws and regulations, or I would go with the, strictest one and agree to abide by that one. And say, you can also say the principles found in, say, the US Foreign Corrupt Practices Act, as opposed to saying, I will actually comply with that law, but I will comply with the principles of that law. So that's not submitting yourself to the jurisdiction of that law, but it's saying these are our standards.
And I would say that internally, wherever you are on your journey with respect to ethics and compliance and anti-bribery, internally you should have the expectation that you're going to meet the highest standard. So you might not want to put that in your contract, but at least internally, that should be your expectation. Partly because how can anybody keep track of what the differences are? And you don't want to run afoul, right? Like right now, I believe the United States is the only, like the FCPA is the only anti-corruption law that still allows facilitation payments, or I guess they call them facilitating payments, which nobody else calls them that. In Canada, we call them facilitation payments. So Canada and the US were the last two holdouts, but our law changed in 2017, and our government announced 3 years prior to that, this is coming out. We're giving you, advance notice, so get ready. And so we all know that companies are all lean machines. And so it would just take too much administrative power to really say, okay, I'll follow these rules for that country and these rules for the other country.
Yeah.
We all know it's roughly centralized. And so they should just pick the highest standard, set all their internal processes to that highest standard. And then in the contracts, you know, something like the applicable laws, but at least internally have that higher threshold for themselves. But honestly, I don't think it matters to the employees, right? Like at the end of the day, internally, the message is like, don't bribe,
Yeah.
right? Like it's
And
not
that's a simple
complicated.
one.
That's an easy
Yeah.
one.
So
Yes,
quick, we
and-
only have a couple minutes. I was going to ask one last question, which I think will be really useful for everybody, which is how should somebody learn about compliance, especially within the realm of the contracting world, kind of a practical, not to become a compliance professional, but to get a good grounding? What are the resources that you recommend?
Do you want to go first?
Well, we only have 2
I'll let you
minutes, so I
take it.
think I'll just have one of you
say,
answer.
okay, I would say the books that I started with were written by Alexandra Rage, W-R-A-G-E, and her books are great because they basically do case studies, but they're written like adventure or like spy novels
fun.
almost. So they're based on real stories. Sometimes they identify the parties if they were in the public domain. Sometimes they don't. And that's the best grounding because it shows you from a business point of view, industry by industry, corruption scandals or like just basically sneaky things that have happened right under the noses of lots of people who would never think they'd be fooled by something like that.
Yeah, that's great. I've had
And I-
those myself, so.
I
Asha,
love
you wanna
it.
sign off for us and anything else you wanted to close with? I'll let you, Amy, you close with something too.
Yeah, of course. And I think, you know, there's blogs out there. We at Conversant have a Converge community where we talk about a lot of compliance issues, and, you know, we'll make sure we continue this conversation there too. I think, you know, finding the interests about, you know, these subjects we talked about is really easy. And we can continue the conversation for sure.
Amy, any parting thoughts before we sign off?
I was just trying to answer one of the people who'd asked who the author was. W-R-A-G-E, Alexandra Rage. I just want to say thank you very much for inviting us, Laura. And what I'm excited about today is that we don't always see enough of an intersection between the transactional lawyers and the ethics and compliance people. And so we seem to be in two silos. And so I'm glad that Asha and I can sort of bridge that gap because we all have a lot to learn from each other and we need each other. So that's my message. So thank you.
Yeah, no, thank you both so much. And thanks to Law Insider for sponsoring the webinar. And everybody will get their email tomorrow with a link to watch the video again and the handout. So thank you again, Asha and Amy, so much. And thanks to everybody who tuned in.
Thank you. Thank you very much.
Thank you. Bye.